Hi, my name is Charit Veera. Today I'm going to present about the impact of generative AI on trademark law. Given the rapid development of artificial intelligence, it is very important to understand how the traditional trademark law is coping with this new development. In this presentation, specifically, we try to identify key issues relating to the legal implications of potential trademark infringement when using the generative AI such as OpenAI, ChatGPT, or the Google Bard. In the presentation, firstly, we pay attention to the key element of the subject area. What is the trademark? How the trademark infringement happened? And how the artificial intelligence come into the context. Then we try to identify some key particular issues relating to the subject in order to suggest some recommendation how the traditional trademark law should adapt to tackle this new development. Let's begin with the trademark. According to the Article 15, subsection 1 of the TRIPS agreement, any sign capable of distinguishing one good or service from a one undertaker to another undertaker is a trademark. However, in order to get this trademark rights, the undertakers or the company should register it with the competent authorities. In the UK, it's the UK Intellectual Property Office. In the EU, it's the EU Intellectual Property Office. In the global context, it's the WIPO, World Intellectual Property Office. Now, the legislative enactments in the UK is under the section 1, subsection 1 of the uh, Trademark Act 1994, which amend certain times to reflect with the development in the EU, especially the EU Digital Service, EU Trademark Regulation 2015. Section 1, subsection 1 of the Trademark Act now identified the unconventional uh, signs, such as the 3D or multimedia signs or the smells, to include into the definitions of the sign which are capable of registering. However, in order to register with the competent authority, the sign should have a clear and uh, precise attribute, and also it should capable distinguishing one product from another. This criteria is developed through the CJEU case Sykman, which normally called as the Sykman criteria. It's defined the sign should be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. If the new sign is failed to produce these met these criteria, it would not be registered as a trademark. The competent authorities can refuse the registration under the absolute grounds or the relative grounds. We'll look into that on identifying the issues, how this criteria and this requirement is affecting these things. However, now trademark infringement. Trademark infringement happens when one of the registered trademark is similar or identical product from a third party is used in a trade relationship, which will confuse the customer and which will give an unfair advantage to that third party, or which will make a detrimental treatment to the registered trademark. Now, artificial intelligence is the machine's learning systems which train to perform some human functions without human interference. Now, its most common form of the artificial intelligence is general artificial intelligence, or AGI, which is the current most current form of the artificial intelligence, and also with this artificial super intelligence, which may be the future, with superpass the humans' ability to perform the task. When it comes to the certain task, how would it potentially infringe the trademark law? The first key issue identified in this area is when the trademark registration process begins. If a producer use generative AI to produce the sign in order to register as a trademark, what would happen? If that sign is identical or similar to a registered trademark, it would be refused under the relative ground of refusal in the UK's Section 5 of the UK Trademark Act, or in UK's Article 8 of the EU Trademark Regulation. When assessing these applications, uh, the criteria of the legislative act is considered, and if the competent authority refuse, it's the court to decide is it capable of registering as a trademark. Now, court use different criteria to decide these decisions. According to the decided cases in Lloyd Mayer and Teva Pharmaceutical or Ruzio Picasso, all these are CJEU cases, define that it will consider the nature of the product, targeted market of the product, uh, to decide this thing. And the main concern is that is this similarity is making confusion or likelihood of confusion to the average consumer to give an unfair advantage of the new applications registered. Now, question on this is that the court, the using that assessment is that average consumer is confusion because of these things. But if the generative AI is using to purchase the new product, would that be the same applicable to making the confusion? No. Human can be conflicted because the imperfection of the recollections of the memory. But AI could train to understand the differences. So therefore, there's a clear disadvantage for the new product when it comes to the registration if it's refusal on the traditional relative grounds. The second issue is arising on the other side of this registration process. If if the competent authorities use AI to make the registration process, would there be infringement? Yes, potentially there is. But it could also argue that it could avoid this potential infringement because the AI could train to do it better than the humans. Now, the third and the most important issue is arising if a generative AI use the science as a prompt to search for the product in order to purchase. If AI search a counterfeit product, who would be liable in the keyword advertising things? Is it the seller or the intermediary like Amazon or eBay? Or is it the AI? Or is it the user who input the keyword? Now, this also is a new area for the law. But looking at especially the EU decisions on this area is suggesting that the court is uh, using in a Google France case or the L'Oreal versus eBay case that the intermediary and the AI companies could avoid the potential uh, trademark infringement liability on their part. Looking at this development, it is easy to suggest that the traditional trademark law is not capable of understanding these new developments. Authors such as Lee Curtis and Rachel Platts in the article of trademark law playing catch up, and the article AI is coming, it will change trademark law, suggesting that the current law is not adequate to tackle these new areas. And we can easily agree because these revolutions on this is not capable with the traditional law to understand. And therefore, it is very important the courts and the lawmakers to understand this new development, and it should pay the correct attention to tackle with this new development. So let's summarize what we talk about today. That's the trademark, potential trademark infringement when using the generative AI is is an issue. It could happen when the application is made for the registration. It could happen when the generative AI is used to make the purchases. So these areas is inadequate in the current law to tackle. Therefore, the current law should recognize this new development, and the revolution is happening with the human purchasings, and it should adapt new method to address with this thing. Thank you.